Ma'am, I want to say that I want to give notice to reserve all my rights and inform the court that I'm not here to testify or plead. I'm here to make a special appearance to challenge the jurisdiction only. I would like to see evidence of the affidavit of the people that I've hurt. This is a victimless crime if there's no one that I've hurt. Objection hearsay. Objection hearsay. I'm not a sovereign citizen.
We open this hearing with a man who thinks he's about to outsmart the entire justice system. He stands up, looks at the judge, and boldly declares, "Ma'am, I'm not here to testify. I'm not here to plead. I'm here for one reason only, to challenge jurisdiction." Oh boy, here we go. Another self-proclaimed legal scholar who somehow believes a speeding ticket can be erased with a few magic words. He demands to see an affidavit from the people he supposedly harmed.
Mr. Robinson, are you here?
I am here representing the name, ma'am.
All right, you need to start your video, please. And you are, is it Tremaine or Tremaine?
The name I'm representing is Tremaine.
Tremaine. And how do you pronounce your middle name?
J.
Tremaine J. Robinson.
On and for the record, ma'am, I want to say that I want to give notice to reserve all my rights and inform the court that I'm not here to testify or plead. I'm here to make a special appearance to challenge the jurisdiction only.
All right, anything else?
Yes, I would like to see evidence of a charging instrument.
Were you not given a copy of the ticket issued by Trooper Collins?
The charging instrument that I am referring to is a sworn affidavit of the client, of the person that I've hurt.
Now, this is a speeding ticket alleging that you did on March 27, 2023 at 8:48 a.m. operate a motor vehicle in Butler County, Kansas at the speed of 92 miles per hour when the posted maximum speed limit was 75 miles per hour. So this would have been out on the Kansas Turnpike, Highway I-35. Now, what else were you wanting to know, sir, as the allegations against you?
I would like to see evidence of the affidavit of the people that I've hurt. This is a victimless crime if there's no one that I've hurt.
According to him, this is a victimless crime. Yes, you heard that right. In his mind, if there's no direct victim, there's no crime. But here's the reality. Speeding laws don't exist because one person got hurt. They exist because driving 92 miles an hour on a highway built for 75 is dangerous to everyone around you. It's about public safety, not waiting for an accident before holding someone accountable. Still, he doubles down. He insists he needs proof, a signed affidavit with not one, but two signatures. Like this is some sort of medieval duel where unless someone cries foul, nothing counts. And when the judge explains that the victim in this case is the state of Kansas itself, he shakes his head like he's just uncovered a massive government conspiracy. And let's not forget.
Well, the victim would be the state of Kansas in that you violated the laws enacted to protect the people of the state of Kansas, but this is not the type of crime which would require or have individual names listed. So your next point, if any?
My next point is, as I said, ma'am, I'm not here to testify. I'm not here to plead. I would like to see the affidavit with two signatures for the person that I've hurt. If I didn't hurt anybody, there's no crime.
All right, well, I'm going to proceed. The subpoena was issued July 7, 2023 for Trooper Collins. Then on July 31st came a correspondence from the defendant as referred to by Mr. Regier herein. Looks like it's about 7 typed pages, and as counsel said, it's entitled Challenge for Jurisdiction and addressed to Butler County District Court Clerk, Butler County District Court Clerk, Office of the Attorney General Derek Schmidt. And it mentions subtitles, under the following case law, I request case 2023 TR 1193 be dismissed. Pretty much standard language that is used by folks who call themselves or are considered sovereign citizens. Quote, it is on this date, July 27, 2023, I, Tremaine J. Robinson, it's Tremaine-J, Robinson, in the county of the Seminole of the state of Florida and a zip code, a natural man, attorney in fact, as a living human being who's the beneficiary of Tremaine J. Robinson trademark. Swear that the information in my sworn statement is truthful to the best of my knowledge and understanding. I, Tremaine J. Robinson, beneficiary of Tremaine J. Robinson, revoke my signature on any and all pages of any and all tickets, summonses, contracts, and or agreements signed by the side of the road in the state of Kansas by Officer Collins K. And so here we are. Now, Mr. Robinson, normally I would be upset that you filed what appears to be in part a motion for discovery and you didn't get that. However, you did not address that document to anybody but Butler County District Court Clerk Traffic Court, Butler County District Court Traffic Court. You sent one to a P.O. box in Topeka, and then you sent a copy of it to the Attorney General. But you did not send it to the Butler County Attorney. Therefore, he did not know you were trying to get discovery.
Ma'am, I do have a tracking number that says it was delivered at the Butler attorney.
Okay, well, that's not on file. What you want to present that at this time?
Yeah, someone signed for it.
This entire hearing is over a speeding ticket. Not a felony, not a life sentence, just a simple fine. But instead of paying it, this man shows up armed with pages of sovereign citizen jargon, quoting fake case law, swearing he's not a sovereign citizen while sounding exactly like one. Then comes the kicker. He claims he filed a discovery motion. But wait for it. He sent it in the mail the day before his trial. He even brags about having a tracking number, like that's going to impress the court. Newsflash, filing last-minute paperwork doesn't buy you a get-out-of-ticket-free card. Judges aren't in the business of...
And this document that I'm giving the benefit of, it's a multi-subject document, but this document filed by the defendant that I'm giving the benefit of, including what he offers as a motion for discovery, was not filed with the clerk until July 31st. So that was after the statutorily required 21 days. And then it was not filed upon the prosecutor who would have, or the witness who would have held any evidence, but rather again on Butler County Clerk in Topeka, Kansas, that to my knowledge doesn't exist, the Butler County Clerk in El Dorado, and Attorney General then Derek Schmidt in Topeka. And that's if it was served, if I take the defendant's benefit of the doubt, that it was saying it was served sometime yesterday before today's 1:30 trial, the court has to decide if that later time was reasonable. And I do not find that it was reasonably served on the county attorney. I am at this point going to say that any last minute motion for discovery is denied and we are prepared to go to trial. Now I've lost you, Mr. Robinson. Are you still somewhere available?
No.
What are you doing there with your computer?
Right now, I was looking for a document, but no, I am not available for trial.
Playing oops, check the mail every time someone wants to stall. At this point, the judge has had enough. She makes it clear his so-called discovery was late, improperly served, and not valid. The trial is moving forward whether he likes it or not. And what does our legal genius do next? He pulls the ultimate smug move, turns his camera away, and says he's not available for trial. Not available? In court? Folks, this is the kind of arrogance that gets you held in contempt real fast. The judge warns him, get back on camera or else. But he doesn't stop. He interrupts, objects to...
Going to proceed with trial. So please put yourself back in front of the camera. Follow the court's order, or you could be found in contempt. I don't want to do that. Thank you, sir.
Your Honor, in that particular case involved a sovereign citizen, where the court noted in the memorandum opinion.
Objection, hearsay. Objection, hearsay.
Case law is not considered hearsay or...
I'm not a sovereign citizen.
All right, he's not a sovereign citizen. Go ahead, Mr. Regier.
Yes, Your Honor. In that case, the Kansas Court of Appeals noted, quote, the defendant thinks the law does not apply to him. He avows that he, unlike other citizens, is sovereign and immune from prosecution. The court went on to address the issue of venue, which the court noted that, quote, venue is generally proper in the county where the crime was committed. I will address that momentarily, as well as referring to KSA 22-2602. Additionally, and perhaps most relevant to this court, the defendant in that case, quote, complains that his objections to the trial court's jurisdiction to prosecute him arise from the claim that he is a sovereign citizen. This is not the first appellate court to deal with such a claim. Another panel of this court used analysis of federal case law to reject a similar claim. And then quoting from Seventh Circuit and Eighth Circuit cases, quote, an individual's belief that his status as a sovereign citizen puts him beyond the jurisdiction of the courts has no conceivable validity in American law. Regardless of an individual's claimed status of descent, be it as a sovereign citizen, a secured party creditor, or a flesh and blood human being, that person is not beyond the jurisdiction of the courts. These theories should be rejected summarily, however they are presented. And with that, I would respectfully call my first witness to the stand.
All right. I do find that this court has jurisdiction and venue to proceed, and the arguments made by the defendant in the 7-page document referred to previously are...
Case law being cited shouts objection, hearsay at things that clearly aren't hearsay, and repeats over and over, I am not a sovereign citizen, and yet every word out of his mouth screams the exact opposite. The judge listens patiently, then firmly declares the obvious. This court has jurisdiction. The venue is correct, and his 7-page legal manifesto is nothing more than sovereign citizen fantasy. It's over. His carefully crafted nonsense just evaporated in seconds. Now the state calls its first witness, the trooper who wrote the ticket. Straightforward testimony. He clocked the defendant at 92 and a 75. Done. No theatrics, no drama, just facts. When the judge offers him a chance to cross-examine the officer...
And did you ultimately write the defendant a citation for speeding?
Yes, I did.
Or an annual redirect? No further questions.
All right, Mr. Robinson, this is your opportunity to cross-examine the trooper. You can question him about his testimony. It's not quite time for you to give your own testimony, so these addresses to the trooper have to be in the form of question. You don't have to question him, but you can. Would you like to?
No.
All right. Mr. Regier, any further evidence?
None from the state, Your Honor.
Okay. The state rests then, Mr. Regier?
The state does so rest, Your Honor.
Mr. Robinson, the state rests. They have presented all the evidence they intend to. Would you like to present any evidence? Again, you don't have to. Your silence will not be used as a sign of guilt. But if you'd like the court to consider your position, I'd be happy to do so.
I don't understand.
Well, do you want to tell the court your version of what happened?
No.
All right. You don't wish to present any evidence then. Am I understanding you correctly?
The evidence that I tried to present, you won't give due process.
Okay. But do you want to give any testimony about the events leading up to this ticket, March 27, 2023?
No.
All right. Well, I will find the defendant guilty of speeding 92 and a 75. The scheduled fine is $87. Court costs are $108. The total due will be $195. Sir, you do have the right to appeal this proceeding. You can appeal it to the Kansas Court of Appeals. You have up to 14 days to file that notice of appeal. Your appeal bond will be in cash, the same as what your court costs and fines are. That's $195. Can you have this paid, this fine and cost paid in 14 days, or do you need some time?
I'll follow up.
This man stares blankly and says, no, that's it. His one shot at actually challenging the evidence, and he throws it away. And from there, the cracks in his defense only get deeper. The state rests its case. The trooper has testified, the evidence is on the record, and the ball is now in Mr. Robinson's court. This is the moment where, if he truly had some groundbreaking defense, he could step forward and finally present it. But what does he do? He just sits there. The judge patiently explains that he doesn't have to testify, but this is his chance to tell his side. Instead of taking it, he mumbles about due process and how his evidence isn't being considered. Yet when asked directly if he wants to present testimony, he says no. And with that, his entire defense collapses. The judge wastes no more time. She rules him guilty of speeding, 92 and a 75. The fine, $87. Court costs, $108. Total, a whopping $195, that's it. Less than $200. And he dragged this circus through months of paperwork, sovereign citizen rants, and courtroom nonsense just to end up paying the exact fine he could have paid on day one. The judge even reminds him, if he wants to appeal, he's got 14 days. But here's the kicker. He'll have to post the same $195 in cash as an appeal bond. So even if he files, he's still out the money. And there he sits, looking absolutely crushed. This man thought he had uncovered some secret legal loophole, that his sovereign citizen word salad would make the entire system bow to him. But in the end, the judge didn't blink. His 7-page legal manifesto went straight into the trash, and his confidence dissolved into silence. Here's the reality. Sovereign citizens love to believe they're one step ahead. They quote random case law, shout about jurisdiction, and declare crimes victimless, as if the entire justice system just forgot how laws work. But the truth? Those arguments have been tossed out of courtrooms across America for decades. Judges don't even entertain them anymore. They shut them down instantly, just like we saw here. So what did this man gain from all of this? Nothing but wasted time, wasted energy, and a public record of him looking like a fool. If he'd just paid the ticket, it would have been over months ago. Instead, he turned a minor traffic citation into a courtroom spectacle, and in the end, he still had to pay up. But let's be real, something tells me he's not done. People who talk like this rarely stop. He'll probably appeal, file more nonsense, and keep convincing himself he's winning when really, the law just keeps rolling right over him. What do you think? Was this guy genuinely convinced he had a chance? Or was he just dragging this out to avoid paying $195, knowing he'd lose all along? Drop your thoughts in the comments because I'm dying to know how you see it. And as always, if you enjoy watching these sovereign citizen fantasies crash and burn in court, make sure to hit that like button and subscribe for more wild courtroom showdowns.